distinguished speaker for this 15th Nani Palkhivala Memorial Lecture, special invitees, faculty colleagues, student friends, friends from the print and electronic media. A very good evening to all of you. I'm extremely happy to welcome the speaker for this afternoon session on behalf of the School of Law at Shastra, on behalf of the Bar at Thanjavur, on behalf of the general public at Thanjavur, on behalf of the management, faculty, students, and on my personal behalf. For I consider that this session is very unique for a variety of reasons. First, to my knowledge, this is the first session that Mr. Gopal Subramanium is addressing an audience at a school of law in a university after his recent recognition as an honorary member of the Grace Inn in London. Which is, on one hand, a recognition of the levels of intellectualism that he has attained, contributing to the evolving jurisprudence as well as enriching the quality of the bar. And on the other hand, also reminding us that given an opportunity to engage with bright students, he never he misses such an opportunity. On that count, I must thank you, sir, for accepting our invitation to address this audience. The second reason about which I tweeted, and many of you asked me what it is. I've always had the desire to have Mr. Gopal Subramaniam address our students as many times as possible. And for those who were here last time when he came, his marathon session is still fresh in our memories. And I would often ask this question, how I wish he was here as many times as he could to address the audience. And then came an opportunity which I grabbed. I didn't want to let go of it. And ladies and gentlemen, in a few minutes from now, I will, on your behalf, take the honor of having Mr. Gopal Subramaniam as a distinguished visiting professor of constitutional law and jurisprudence at Shastra School of Law. And that, again, is a wonderful opportunity, a learning opportunity, not only for the students, for the faculty, and for the general intelligentsia here. And the third important reason why that this session is unique, it is a rare coming together of an event that we organize every year in honor of one of India's outstanding jurists, Nani Palkhivala. And in his honor, we have the honor of hosting a very distinguished jurist himself. And for most of you, you already know the greatness of Nani Palkhivala. Not only was he an outstanding jurist, a great diplomat, a scholar, a silent philanthropist, a corporate leader, and he excelled in all these fields. And we always have this tradition of inviting the best to deliver the Nani Palkhivala Memorial Lecture. And this time, we have just gone one step ahead. And this is the first time that we are inviting the same speaker twice for the same purpose. We have Mr. Gopal Subramaniam delivering the 15th Nani Palkhivala Memorial Lecture, and the last that we heard him was when he delivered the 11th Nani Palkhivala Memorial Lecture. And this is a rare coming together for which there is a specific reason. And all of you know how much is the contribution of Nani Palkhivala in protecting the foundational architecture of the Constitution, when he ensured that the fundamental rights of every individual is protected. And that was to protect the text in the Constitution. And today as well, we have a similar scenario. A paraphrased scenario. It is not the constitutional text per se, but a derivative of the Constitution, if I can say so, on the term constitutional morality, which is something that is not in the text form of the Constitution, but used charitably in recent times. It was used as constitutional trust, which is now also called constitutional morality, to recognize the role of institutions, the role of a prime minister, the proceedings inside the legislature or the parliament. Now, this type of institutional safeguards was possible because of these derivatives, namely constitutional trust or constitutional morality. And the same paraphrasing to protect, in the name of protecting rather, individual rights is something new, which is emerging. And it is also confusing that such phrases, which over a period of time might change the way in which it is understood, to be branded as even a franchise of the Constitution, if I can call so. You have franchises today. You have TTD franchise in Venkat Narayana Road. You have Kumbakonam Degree Coffee franchise in somewhere in Jalandhar or somewhere in the north. So is the original quintessence, will it be watered down, is an area of concern and also an area of great confusion. And that is why we thought it is necessary that we have somebody who can create an enlightened constitutional vigilantism, which is necessary to ensure that you understand the text and spirit behind the Constitution and the other derivatives that are emerging in the contemporary discourse that is held at all places. And we couldn't think of any other person better than Mr. Gopal Subramaniam himself to come and clear our confusions, to address our concerns with clarity. So, ladies and gentlemen, please put your hands together and welcome Mr. Gopal Subramaniam. I don't want to take much of his time, but just want to recall that the last time that you addressed this audience, sir, it was a marathon session of close to around 150 minutes plus. Not a single soul moved. You had that intellectual prowess that magnetically attracted students to the knowledge that you were sharing with you. And I'm reminded of that conversation that Mahatma Gandhi had with Kanchi Mahaswamigal during lunchtime. And it was stretching beyond the lunchtime. And it was only Rajaji who could intervene and request Mahatma Gandhi and say, it's time for lunch. And Mahatma Gandhi said, I'm already having a feast. So, sir, I dare not intervene when you actually do the talking. There is enough time for you. And we are all in for a feast. And how much time you want to take is your calling. And after I close down with a few formalities to follow, please be ready for the feast. Thank you very much.
Thank you, sir. May I now request our Dean, School of Law, Dr. P. Ravishankar Raju, sir, to present the memento as a token of our appreciation to our guest of honor. Thank you, sir. May I now request our Honorable Vice Chancellor, Dr. S. Vaidya Subrahmanyam, sir, to present the Distinguished Visiting Professor plaque to our Chief Guest.
I just take the honor of reading this. Shastra deemed to be university. This plaque is presented to Shri Gopal Subramanium, Senior Supreme Court Advocate and Honorary Member of Grace in London, for being inducted into Shastra School of Law as Distinguished Visiting Professor of Constitutional Law and Jurisprudence, signed by the Vice Chancellor on March 30, 2019.
Thank you, sir. It is with a great source of pride that I invite Shri Gopal Subramaniam, sir, to deliver the 15th Nani Palkhivala Memorial Lecture 2019.
Respected Dr. Vaidya Subrahmanyam, the Vice Chancellor of Shastra University, Dr. P. Ravishankar Raju, my young friend, Mr. Vishwas Bharadwaj on the dais, former Advocate General, Mr. Navanitha Krishnan, distinguished members of the faculty in the university, and my colleagues at the bar, and of course, the brilliant students of the morrow in this university. Nani Palkhivala undoubtedly was a legendary lawyer, and it is befitting that any faculty of law must have an avenue which is named after him. You would have read many eulogies about Nani Palkhivala, but there is another way by which you can know about Nani Palkhivala, that is to hear about him from those who came into touch with him directly. I have to my advantage the benefit of the eulogies, but I also have to my advantage my personal recollections of meeting the late Mr. Nani Palkhivala. I would prefer to rely upon the latter and share with you in the very opening 3 remarkable qualities which stood him out in the world of law and actually made him the stuff that legends are. First was his exemplary humility. I'm reminded of the words of Tagore. We come nearest to the great when we are great in humility. Second, a deeply committed and passionate lawyer to the ideals of the Constitution. And third, a ceaseless advocate who was informed by the spirit within him. We must begin today with some important philosophical assumptions, and they are necessary in the light of what the Vice-Chancellor has remarked as the setting for a debate on constitutional morality. As all of you are aware, that there has always been a debate that where does this expression, morality, come from? Is it connected with conscience? And what is therefore conscience? As far as conscience is concerned, we have had a very elaborate exposition of conscience by Thomas Aquinas in Summa Theologiae. And above all, we must bear in mind that according to Thomas Aquinas, conscience is something which binds man to a sense of what is right, distinguishing it from what is wrong. Now, this is one view. At the same time, we must bear in mind that David Hume formed an opinion that the foundations of morals may be based on sentiment and not necessarily reason. But we are taken back to Descartes, who said, "Je peux donc je suis, I think, therefore I am." This also takes us to the field of existential moral psychology, which has always concentrated in human freedom, of which we have had great exponents in Simon de Beauvoir, Camus, and all of them saying that this is something special, which is not in the usual conceptual repertoire of human thought. I want to bring to your notice that I was very pleasantly surprised at social liberalism, which also will have some bearing on our discussion today, of T.H. Green, and of course, the later analytical philosophy, which was set out by Bertrand Russell. But one of the greatest philosophers of today, who is no longer with us, is a tremendous British philosopher, Derek Anthony Parfit. He wrote a wonderful book called Reasons and Persons, and he developed the concept of ethics being impersonal. According to him, rationality and time necessarily was important, and he believed that there were no future facts, and all that man could really remember was his best fact and best memory. These are some of, shall we say, the philosophical foundations of morality which are born out of existentialism but resonate in some sense with the soul. The question is, if this is the meaning of morality, is it a subjective meaning, or is it a meaning which can be objectified? I am going to urge for your consideration that, based on jurisprudence and political theory, there can be no manner of doubt that constitutional morality is an objective standard. The Vice-Chancellor spoke about the spirit of the Constitution. How do you protect the spirit of the Constitution? Because there could be adherence to the letter of the Constitution. His concern is entirely justified. Therefore, to start with, I would urge you to consider that Nani Palkhivala made one of the most outstanding contributions in the evolution of Indian constitutional law in Keshavananda Bharati, where the Supreme Court held that the basic structure of the Constitution could not be emasculated. I'm a firm believer that effect of recent developments is that this idea, which has always lived just below the surface of the Indian Constitution, in the way Dr. Ambedkar conceived of it, has finally begun to flower. In a host of debates about the Constitution's meaning, ranging from federalism to religious freedom, the idea of constitutional morality has become the device by which hard constitutional questions can be answered without giving up the discipline that legal reasoning imposes on us. I hope to show to you the power of constitutional morality as an idea for constitutional adjudication in the courtroom, and more importantly, for engaged and enlightened Indian citizens in the everyday life of democracy, in uncovering the meaning of the document and in ensuring that each successive generation of Indians always have the dynamic and living Constitution. The unavoidable limits of language is obviously the legal language. First, the origin of the spirit of constitutionalism lies in human nature and social contract. The first act of a parliament, and we talk about the Indian Parliament, was only a few months after the Constituent Assembly had decided to adopt the Constitution. This was by way of the First Amendment to the Constitution. But the First Amendment tells us about the exigencies of managing power as the state. Did the state want more power? And this is relevant in the light of what the Vice-Chancellor said. Because if power is the fundamental praxis of governance rather than principles, and if principles come first and power second, then the situation is different. But if power comes first and then the determination of principles, the question of the spirit of the Constitution becomes vital. Two decisions triggered the First Amendment Act of 1951. The decision of the Supreme Court in Ramesh Thapar's case, 1951 Supreme Court Reports 594, struck down the Madras Maintenance of Public Order Act 1949. And there was also another judgment called Brijbhushan versus State of Delhi, which struck down the East Punjab Public Safety Act. And this prompted Parliament to amend the Constitution and introduce in Article 19(2) new grounds of public order, relations with foreign states, and incitement of offense for the state to restrict free speech. Leaning on the crutch that the freedom of speech was being abused, the government moved an amendment to add further restrictions to a right whose language had already been debated and carefully considered in the Constituent Assembly before being settled on. Parliament did so with the full awareness of the dangers that arrogating to itself such a sweeping justification to restrict a right without which no democracy worthy of the name could survive. In debating this amendment to add the language of public order, the late J.B. Kripalani made an emphatic appeal against its inclusion by warning of the possibilities of the abuse of such a sweeping and open-ended ground by the government. I quote his words, "If a procession is taken out, public order is disturbed. If some students want some facilities in their schools and colleges, public order is disturbed. If there is a hunger march and people want food, public order is disturbed. When public order is thus disturbed, what do the government do? They have ample powers. They use the police. Our police are very good at shooting. They shoot to kill. It does not matter whether it is women or children that they shoot. There is therefore ample power with the government to shoot even peaceful hunger strikers. What more is needed? I do not understand." The amendment was passed, and public order has since its inclusion to present afforded successive governments the cover under which to suppress actions contrary to its comfort without really needing to discharge its duty to justify its actions fully. Arguably, this was a mutilation and an undermining of a right which under Article 19(2) was already capable of being restricted to protect enumerated national security interests. The constitutional morality of Parliament's first act was of questionable constitutional morality. But the acts of channeling power, which was the work of the Constituent Assembly, and of welding it as the Parliament in whom was a repository of legislative power, are very different creatures. Is not a constitution born of idealism? Is it not meant to guarantee optimism? Is it not meant to ensure a successful destiny in our lives? In the rousing stories of the French Revolution, the American Revolution, and indeed in our own moral and extraordinarily principled struggle for Swaraj and self-determination, that narrative is undeniably true. Equally, framers of constitutions across time and place have shown us that constitution making is an exercise in hard-nosed realism. Wisdom over the ages about the Constitution proceeds on a universal truth about human nature, that all men are fallible and that power, however defined, can corrupt. Constitutions are fundamentally instruments by which power is allocated at two levels. It is delegated by the people to their government and its functionaries, and in a quasi-federal system such as ours, it is divided between the center and the states. A corollary of the truism about man's fallible nature is that when any man or group of men is entrusted with a large well of power, we must do all we can through checks and balances. This brings us to the question that Hobbes, Locke, and Rousseau, all put together in their trinity of thought with reference to human nature, understood that in order to have a limitation on governmental power, one needed a set of principles which would be embodied in a constitution, which also found their foundation in the social contract theory. Hobbes, in his Leviathan, spoke about, and I quote those words, "So that in the first place I put for a general inclination of all mankind a perpetual and restless desire of power after power that ceaseth only in death." And then he says, "And the cause of this is not always that a man hopes for a more intensive delight than he has already attained to, or that he cannot be content with a moderate power, but because he cannot assure the power and means to live well, which he at present without the acquisition of more." In other words, power itself has a psychological tendency for self-propagation. It has the attribute of self-accentuation. Therefore, one needs the Constitution as an important check. But how does it check, shall we say, the accretions of power? It does so through the prism of what we call as constitutional morality. I would say that Locke, in his two treatises of government, also set out virtually the same theory. And here he spoke about the plain difference between the state of nature and the state of war. And then he said that mankind, notwithstanding all the privileges of the state of nature, being put in an ill condition while they remain in it, are quickly driven into society. And further, he said that in this we have the original right and rise of both the legislative and executive power, as well as of the governments and societies themselves. Therefore, we must appreciate that constitutionalism is really a facet of constitutional morality. And what is important is that this is a fundamental value. It is not only a creed of faith, but it is the very basis of any journey in judging or in assessing governmental action in the legislative or the executive sphere. Rousseau said, "Man is born free, and everywhere he is in chains. One thinks himself the master of others, and still remains a greater slave than they." Rousseau then saw the imposition of a social contract, a constitution which was capable of bringing about a moral transformation. The passage from the state of nature to the civil state produces a very remarkable change in man by substituting justice for instinct in his conduct and giving his actions the morality they had formerly lacked. On 26 November 1949, Dr. Rajendra Prasad, 2 months before the Constitution came into force, said, "After all, a constitution, like a machine, is a lifeless thing. It acquires life because of the men who control it and operate it. And India today needs nothing more than a set of honest men who will have the interest of the country before them." Dr. Ambedkar was not far behind. He said, "I feel however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot. The working of a constitution does not depend wholly upon the nature of the constitution. The constitution can provide only the organs of state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes and their politics." Hart, in his concept of law, stated the classic version of the problem. Hart said that law is open texture. He borrowed from his colleague, Frederick Wiseman, who used the phrase to explain that language can never perfectly represent meaning or reality. Words are imprecise carriers of meaning. I would like to go further, that judges and lawyers live with the problem of legal indeterminacy. We are daily forced to choose between two alternatives, both of which sometimes can be equally logical. How then do we choose? Can judges turn to policy considerations or choose what they like best ideologically? Can they simply decide based on personal preferences, their religion, their personal moralities? The answer is no. And I will come to that a little later, that constitutional morality is really a process of transcendence. It is a process of impersonality. It is a process by which the judgment is outside one's personal preferences and one's narrow vision. Interpretivists accept this more believable picture of the law. They point us to a resource outside the law's text to find its meaning. Dawkins, for instance, argues that looking to the background affords a necessary and sufficient resource to support legal decisions in cases where the foreground is either disputed or indeterminate. The perfect judge is called by Dawkins as Hercules, and he adopts this approach when confronted with legal indeterminacy. Dawkins explains that constitutional argumentation and decision-making must proceed in the hands of a good faith and erudite judge, abreast of the laws and committed to acting with discipline and the commitment to give reasons grounded in the law and not his personal preferences to arrive at a reading of contested words. The law we like to tell ourselves is reasoned, disciplined, rational. We tell ourselves that the law is different from social and public morality. We are bound by a rule of law, not by a rule of the morals or majority. Legal positivism argues that the boundary between law and morality is a strict one, In other words, the questions of what the law is and of what it ought to be are completely separable. Judges should therefore employ their own moral judgments to determine what the law is. When Dworkin spoke of the judge as a Hercules, he is candid in admitting the limits of law and language, and in the truth of the work that judges and lawyers do. Legal interpretation, although constrained by legal materials, always requires some moral judgment because these legal materials are inconclusive. This reality is doubly true for constitutions. Their whole purpose is to codify a morality. Part 3 of the Indian Constitution jettisons an imperial public morality for, and I shall deal with this a little later, a democratic and republican constitutional morality. Therefore, a moral reading of our Constitution is unavoidable. The question is, whose morality must guide us? The answer is simple. It must be the values of the Constitution and of the founders of the Indian Republic that we apply. Let me now come to the question of a substantive view of democracy. I expect that many of you will vote this year, and that for most of you it might be your first general election. Consider for a moment what democracy must mean. No one will dispute that India is a constitutional democracy. There is, of course, the right to vote that is necessary, and the formal requirement of any government being called a democracy is indeed universal adult franchise. But it would be a seriously emaciated idea of democracy to say that we can simply stop there. It is not simply majority rule. That is governance by the will of the people. It is also the protections for the weak, the vulnerable, and the creation of spaces where dissenters are allowed the same freedoms as those in the majority. So when the preamble speaks about democracy, we can take it to have been realized every time we vote, or we could look to the spirit of the Constitution. We could take the constitutionally moral view of a rich and substantive view of democracy. It is precisely this menu of options that the Supreme Court had before it in ADM Jabalpur versus Shivkant Shukla. Justice Khanna's views in dissent prevail today. The reason for the endurance of his view is precisely that he looked to substance over form, to the real heart of the Constitution, and to the purpose of its guarantees, rather than remaining satisfied with a technical and mechanical approach to the Constitution's words. Justice Khanna was truly a constitutional moralist. We must also not forget that Justice Khanna also tipped the scales in Keshavananda Bharati. Justice Khanna was of the view that fundamental rights and the rule of law had life outside of the Constitution's text. The result in his view is that Indians had a right to life and personal liberty, irrespective of whether it appeared in Article 21 of the Constitution, and inroads into that right could not be made except under the authority of law. Constitutional morality was first recorded by an English historian by the name of George Grote in his 19th century work called A History of Greece. It was borrowed and built by Dr. B.R. Ambedkar. And I say without any fear of contradiction, one of the most learned participants in the Constituent Assembly, who gave so much of his resource and time in the making of India's constitution. Dr. Ambedkar realized very early the important role that constitutional morality would play in upholding the rights and freedoms granted by the Constitution. It's very interesting to note that in his address to the Constituent Assembly on 4th November 1948, he quoted Grote. In his study of Greece, Athens' democracy, Grote had argued that it had become necessary at that time to create in the multitude or the masses in the Athenian city-state the rare and difficult sentiment which he termed as constitutional morality, with the object of through them to forcing a commitment to the sentiment upon the leading men. This was a sentiment to be harbored by the whole of the nation state. And I quote these words, they're of great importance. The diffusion of constitutional morality, not merely among the majority of any community, but throughout the whole, is the indispensable condition of a government at once free and peaceable, since even any powerful and obstinate majority may render the working of a free institution impracticable without being strong enough to conquer ascendancy for themselves. Apart from Athens, there are only two other places and times where constitutional morality came to be realized according to Grote. The first was the events surrounding the glorious revolution in 1688, which led to the passage of the Bill of Rights of 1869 in the British Parliament to set out civil rights and clarify the line of succession to the crown. The second was the birth and flourishing of American constitutionalism in the next century. On 4th November 1948, Dr. Ambedkar quoted Grote and said, by constitutional morality, Grote meant a paramount reverence for the forms of the Constitution, enforcing obedience to authority, acting under and within these forms, yet combined with the habit of open speech, of action subject only to definite legal control and unrestrained censure of those very authorities as to all their public acts, combined too with a perfect confidence in the bosom of every citizen, amidst the bitterness of party contests, that the forms of the Constitution will not be less sacred in the eyes of his opponents than in his own. For Ambedkar, constitutional morality held the threads of the Constitution together. And just in the Dworkinian account of the interpretivist judges, the paramount duty of public officials, including judges, was to give reasons in a manner which kept them intelligible and accountable to layman and lawyer alike. I now come to the Supreme Court. The Supreme Court, in three very important judgments, has touched upon constitutional morality as a fundamental basis of discovering the true spaces within the meaning of rights in Part 3 of the Constitution. Pausing here for a moment, I would like my friends to bear in mind that the Constitution has two texts. It has what is called the rights text, and it has what is called the governance text. The rights texts are actually a check on the governance texts. The governance texts are meant to be exercised in the light of the rights texts. That is why we must understand that without the rights, the powers of governance are entirely arbitrary and too full and cannot be given in a democratic state. Therefore, rights are the bulwark of a constitution and indeed the foundation of any civilized society. We must bear this particular praxis in mind and always take into account that when an action of a government is being scrutinized, we have to see first whether it emanates lawfully from the governance texts. 2, is it for a purpose truly encapsulated in the governance texts? 3, does it infringe the rights texts? And 4, if it does infringe, does it do so legally? And 5, if it does infringe even legally, is it proportionate or reasonable? Having said that, in Puttaswamy, which was a path-breaking judgment, the court held the individual is the focal point of the Constitution. And I think this is actually one of the landmark judgments of the Supreme Court, where the court was not only a custodian of constitutional rights, but in fact entered the discourse of constitutional morality in a completely frontal manner. Thus, the entire edifice of the state in Puttaswamy, according to the Supreme Court, lives and works in the service of allowing each of us as individual citizens to live free and meaningful lives. Second, Puttaswamy said, dignity is an indispensable moral and constitutional value. Third, privacy is a natural right, and natural rights flow from theistic morality, which in turn recognizes and affirms the divinity of the human person. The court has accepted this approach in toto. But why did they say so? The court said, these constitutional precepts exist in unity to facilitate a humane and compassionate society. The individual is the focal point of the Constitution because it is the realization of his individual rights that the collective well-being of the community is determined. I come to a second case, which is in the state of NCT versus Union of India, where the concept of constitutional morality was expressly invoked by the court as a guiding light in constitutional interpretation. This was in the context of deliberative democracy. The Chief Justice noted that constitutional morality is that fulcrum which acts as an essential check upon the high functionaries and citizens alike, as experience has shown that unbridled power without any checks and balances would result in a despotic and tyrannical situation which is antithetical to the very idea of democracy. We must not forget that in our preamble we have the words equality, liberty, and fraternity, and these are actually intended to be the triangular values. This leads to what the Vice-Chancellor described correctly as constitutional trust. The constitutional trust is the trust which is reposed in the functionaries under the Constitution. The trust is that they will be guided by constitutional morality, objective pragmatism, and the balance that is required to sustain a proper administration. They actually expect governance for the betterment of society, healthy relationship, and mutual respect, having an open mind for acceptance. Justice Chandrachud, in his concurring opinion, said, one of the essential features of constitutional morality, thus, is the ability and commitment to arrive at decisions on important issues consensually. It requires that despite all differences, we are part of a common deliberative enterprise. In my view, Justice Chandrachud's judgment actually is the first ascendant step in the matter of interpretation of constitutional morality. Justice Chandrachud goes on to say further, a constitution can establish a structure of government, but how these structures work rests upon the fulcrum of constitutional values. But a sense of constitutional morality drawn from the values of the document enables us to hold to account our institutions and those who preside over their destinies. Constitutional interpretation, therefore, must flow from constitutional morality. So, in the primordial perspective of Montesquieu, constitutional morality not only helped maintain the separation of powers between executive, legislative, and judicial bodies, but also at the sub-levels of governance. In the words of Justice Chandrachud, democracy is not limited to electing governments. In a later judgment, in Krishna Kumar Singh, which dealt with the powers of the executive to promulgate ordinances, Justice Chandrachud said, the court must adopt an interpretation which furthers the basic constitutional premise of legislative control over ordinances. The preservation of this constitutional value is necessary for parliamentary democracy to survive on the sure foundation of the rule of law and collective responsibility of the executive to the legislature. These words of Justice Chandrachud's judgment have special meaning, and I quote, the silences of the Constitution must be imbued with substantive content by infusing them with a meaning which enhances the rule of law. To attribute to the executive as an incident of the power to frame ordinances an unrestricted ability to create binding effects for posterity would set a dangerous precedent in a parliamentary democracy. I come to the next judgment, which is in Nas Foundation. As you're aware, the Delhi High Court had held that popular morality could not inform the law, and it held that a constitutional morality, however, did so. The court held that if there is any type of morality that can pass the test of compelling state interest, it must be constitutional morality and not public morality. The Constitution Bench in Navtej Singh Johar has come to its independent conclusions for the purpose of striking down Section 377. Chief Justice Mishra said, the concept of constitutional morality is not limited to the mere observance of the core principles of constitutionalism, as the magnitude and sweep of constitutional morality is not confined to the provisions and literal texts which a constitution contains. Rather, it embraces within itself virtues of a wide magnitude, such as that of ushering a pluralistic and inclusive society, while at the same time adhering to the other principles of constitutionalism. It is further the result of embodying constitutional morality that the values of constitutionalism trickle down and percolate through the apparatus of the state for the betterment of each and every individual citizen of the state. The society as a whole, or even a minuscule part of the society, may aspire and prefer different things for themselves. They are perfectly competent to have such a freedom to be different, like different things, so on and so forth, provided that their different tastes and the liking remain within their legal framework and neither violates any statute nor results in the abridgment of fundamental rights of any other citizen. I must say that one of the great contributions in this judgment has been that society cannot have a homogeneous, uniform, consistent, and standardized lot of people. Justice Mishra says, any attempt to push and shove a homogeneous, uniform, consistent, and standardized philosophy throughout the society would violate the principle of constitutional morality. Devotion and fidelity to constitutional morality must not be equated with the popular sentiment prevalent at a particular point of time. The concept of constitutional morality would serve as an aid for the court to arrive at a just decision. And later he says, the idea of number in this context is meaningless, like zero on the left side of any number. Justice Chandrachud adds, the conception of constitutional morality is different from that of public or societal morality. Under a regime of public morality, the conduct of society is determined by popular perceptions exist in society. The continuance of certain symbols, labels, names, or body shapes determine the notions, sentiments, and mental attitudes of the people towards individuals and things. I want to pause here, and I want to add a few words at this juncture. This sentence needs to be understood in a strictly psychological sense. When we are enjoined by the Constitution to accord mutual respect, we are meant to transcend our first impulses of cognition, because our mental attitude, seeing a symbol, seeing a label, seeing a name, seeing a body shape, seeing a color, may rush us with a certain thought or action. But it is that thought or action which can be completely deleterious to the process of equality. And that is why Justice Chandrachud says in the next sentence, constitutional morality determines the mental attitude towards individuals and issues by the text and the spirit of the Constitution. I personally believe that this is the best definition you will ever get to see of this expression, constitutional morality. Not only is it an adequate definition, but any definition in the field of logic must serve a purpose. The purpose which this definition serves, it makes you think. That is, our mental attitudes are meant to be determined. We have mental attitudes towards individuals when we meet them, when we hear them, when we see them, when we see works of art, when we see expressions. But it is constitutional morality which determines the mental attitude. It requires that the rights of an individual ought not to be prejudiced by popular notions of society. Constitutional morality reflects that the ideal of justice is an overriding factor. And now all of you will remember that justice is also one of the words in the preamble of the Constitution. Constitutional morality reflects that the ideal of justice is an overriding factor in the struggle for existence over any other notion of social acceptance. It builds and protects the foundations of a democracy without which any nation will crack under its fissures. Then, a little more, we come to a slightly more progressive posture in the reasoning. It is a guarantee, that's constitutional morality, which seeks that all inequality is eliminated from the social structure and each individual is assured of the means for the enforcement of the rights guaranteed. Constitutional morality leans towards making Indian democracy vibrant by infusing a spirit of brotherhood amongst a heterogeneous population belonging to different classes, races, religions, cultures, castes, and sections. Constitutional morality cannot, however, be nurtured unless as recognized by the preamble. There exists fraternity, which assures and maintains the dignity of each individual. Having said this, I would say that the best way, before I move to the next part, is to borrow an excerpt from Mr. Palkhivala. The survival of our democracy and the unity and integrity of the nation depend upon the realization that constitutional morality is no less essential than constitutional legality. Dharma, righteousness, sense of public duty or virtue lives in the hearts of public men. When it dies there, no constitution, no law, no amendment can save it. I'm reminded of the words of Einstein. The strength of the Constitution lies entirely in the determination of each citizen to defend it. Only if every single citizen feels duty-bound to do his share in this defense are the constitutional rights secure. Thus, a duty is imposed on everyone which no one must evade, notwithstanding risks and dangers for him and his family. I now come to the next point, which is, and that is in the context of what the Vice-Chancellor mentioned. What, therefore, is expected from the government in terms of constitutional morality? I say the following. First, it must have the correct perspective of itself. Charity begins at home. And however powerful you may be, you must have the right perspective of your own authority in government. Unless you know that you are limited by the Constitution and you are a servant of the law and the spirit of the Constitution, the first perspective would not have been gained. After the first perspective comes the people who are to be served, namely the citizens of the country. A government must have a perspective towards the citizens of the country. A government must bear in mind that they have their rights, and in a vast diaspora, there are bound to be a pluralism of values, a pluralism of tastes and temperaments. But governments cannot take sides. Governments have to treat all alike. And if there are any marginalized, vulnerable, disadvantaged, whether factually, situationally, government has to protect them. This perspective of the government towards its citizens is the second major premise of constitutional morality. What is the third premise? The third premise is government is an executive government under the Constitution. It is answerable to Parliament. If it is answerable to Parliament and the legislature, it must consider that the legislature is one of the most vital and important instruments where the actions of the executive can be debated, tested, and in fact criticized, including by the members of the ruling party which actually has foisted the government. I would like all people to note that freedom within Parliament was granted by virtue of Article 105, 1 of the Constitution, deliberately. The purpose of this was that even those who belonged to the political party which had actually formed the government could still participate in the parliamentary process and raise questions which were critical of the functioning of the government. If you look at the parliamentary debates in the early years of this country, you will notice that when the first four prime ministers were there, there are umpteen questions which are asked by members of the party, which actually was the party from where the government was formed, which asked questions. Therefore, the protection of parliamentary freedom to enable persons to ask questions, because accountability of the executive takes place in dual forms in our Constitution. It takes place first to the Parliament, and secondly, it takes place to the judiciary. Then I come to the next. Government must be conscious about the extent of its lawmaking powers, including the powers to tinker with the Constitution. No man is supreme under this Constitution. No individual is indispensable under this Constitution. There is no one who can lay a claim to infallibility under this Constitution. There is no individual or a persona designator who enjoys the stamp of eternity under this Constitution. Much as human ambition may be, but the Constitution actually expects a mature, sober, and a more careful reflection on the part of those who govern. Thus, this is another premise, namely, that the executive government must be conscious of the extent of lawmaking power under the Constitution. I then come to another point, the sixth point, and that is a very important point. The rule of law. An executive government which does not feel that the rule of law is its shining knight in companion will be no government at all. Any government which thinks that the law is meant to be simply muzzled will not actually carry forward either the spirit of the Constitution, nor will it carry forward the faith of the people in the working of the Constitution. The voice of people may be sometimes muffled. The voice of people may sometimes not be heard. We do not know the situational circumstances in which the multitude of our country, and particularly those who are underprivileged and who live in the most deplorable conditions, actually come from. While we in this hall are able to debate in an idyllic way on constitutional morality, in this blistering heat, we must not forget our hundreds of individuals, young children, men and women, who do not know from where their next day's labor shall come. It is an important point. The point being that unless and until there is an excessive consideration for the rights of all, and that is a creed of faith in the rule of law, and a government is wedded to the rule of law, not by compulsion, not by legal advice, but as a part of its innate nature, as a part of its intrinsic character, I'm afraid the spirit of the Constitution will not be subserved. Number 7, the attitude of the government towards the most important component of the state under the Constitution. The custodian of the Constitution, the silences of the Constitution, the balances of the Constitution, to see whether the limitations of power imposed by the Constitution have been adequately addressed by executive government, is the role of the judiciary. An executive government must have the correct attitude towards the judiciary. An executive government is at arm's length from the judiciary. It is completely unexpected of the Constitution that executive and the judiciary work hand in hand. There is no hand in hand as far as the executive and the judiciary under the Constitution is concerned. The meaning of the expression fear or favor, which occurs in the Schedule of Oaths to the Constitution, bear different meanings for those who actually are members of the legislature, or those who adorn ministerial offices, and those who actually are sworn in as judges of the superior judiciary. The meaning of the expression fear or favor, which is for judges, has a completely different signification. Fearlessness and without any favor implies the highest stands of distance and detachment from the executive at all points of time for an independent judiciary. An independent judiciary is an equally sacred task of the executive. The executive cannot lay its blame for any comments on the judiciary at the feet of the judiciary itself. It has as much a vital stake in public credibility in the workings of the three organs of the state. Thus, if the spirit of the Constitution has to be subserved, public faith in the Constitution must actually be fostered. Public faith in the working of the Constitution can be fostered only when we find that all these premises are actually inviolable articles of creed which are embraced by men in power, whoever they be, whatever political party they may belong to, but they are committed to the welfare of the people, but ultimately the sacred text of the Constitution. We must not forget that our Constitution is a byproduct of immense labor, toil, sacrifice. We must not forget that so many men and matters have actually come to pass before we claimed our tryst with destiny. Our tryst with destiny must not be chimeric. Our tryst with destiny must not be controlled by any form of media simply. Our tryst with destiny must be felt within our own hearts as far as the manner in which we feel the Constitution is living for ourselves. The surroundings outside us must be able to tell us how good is the Constitution working for us. The surroundings within us, our climate within and our climate without, must be able to tell us how good are these premises. Are these not the correct premises? Are these common grounds? Are these not the premises on the basis of which constitutional morality is meant to be established? If the Supreme Court has taken leaping strides in the development of jurisprudence as it has done, and it may have done, and it has done so, not in a very long period, unlike in the United States, unlike in many other jurisdictions, including common law jurisdictions, India must be a proud country that in the year 2019, we have judges of the Supreme Court who have said that even the silences of the Constitution will be imbued with the deepest spaces of constitutional morality. What are spaces? And that is the ninth and the last. A government must also understand that it must give every citizen his space. Every citizen is entitled to breathe in a space. He's entitled to feel in a space. He's entitled to suffer his cognition, his problems, deliberate, imagine, and write and express. He has his own individual universe. It is that universe which is guaranteed under this Constitution. If we do not see each individual as unique as the other, and that is what modern genetics has helped us, and the evolutionary theories of today have only advanced our own beliefs that every one of us has enormous kinetic potential of extraordinary nature, which are actually being unfurled by greater and greater discoveries in the form of genetics and understanding of genetic mutations. But I must add, as a footnote of caution, that although I am not a particularly avowed scientist, but as one who has respect for sciences, that if we allow fear of understanding the Constitution, the fear of allowing the light of the Constitution to invade our recesses of the mind, if the fear of circumstances within and without actually control our being, then I'm afraid we also will suffer a mutation in the progress of time. There is far too much at stake in our actions. Our actions make the Constitution, and our omissions may actually put the Constitution at peril. Therefore, we also as citizens have as much a duty. Our duty is also that premise that we are equally responsible for the Constitution. We are the proud inheritors of the Constitution, and we will ensure, as not simply merely narrow-minded persons who speak about morality in a subjective form, but objective constitutional morality, to insist that executive, legislature, and all the organs of the state work on common assumed premises of, shall I say, the greatest common good. To conclude, I would like to say that the philosophy of religion is also somewhat significant. Our Constitution gives religious rights, but our Constitution also gives rights of conscience which may exclude religious rights. In other words, a person may not be religious, but he may still act out of conscience. It is well known that atheists cannot be devoid of conscience. It is also true that agnostics cannot be devoid of conscience, as long as we have a man, and a man with a mind. And that is where we come to one of the most important parts of Western thought, and, shall we say, the theory of ethics and the theory of morality. As long as man has a mind, and as long as man has a situation in front of him, his ethical sentences may not express propositions, but they do project emotional attitudes as thought, as if they are real properties. And this is indeed what is today called as the Blackburn's challenge in modern philosophical discourse overseas. But I'll leave that aside. Suffice it to say that whichever way we look at our position, and we don't have to look at it necessarily through the eye of religious freedom. You, of course, have guaranteed religious freedom. You have denominational freedom that can never be taken away. But more importantly, you have the freedom of conscience. The freedom of conscience is in some sense a part of the freedom of human dignity, and as much as a part of, shall I say, human liberty. I would therefore say that if there was actually, shall we say, an amalgam of Kantian deontology and also consequentialism and contractarianism, and all the three put together, we would still arrive at what I believe these premises which I mentioned, 9 for the state and 1 for us the citizen, the tenor, as a charter of what I believe to be modern social liberalism, which will stand even the test of what, shall I say, which will stand the test, and more importantly, as Derek Parfit has put it brilliantly, it would protect the future self. It would be as good as population ethics, which explains environmental laws, which is meant to protect the environment. Similarly, I think the future will be safe and sound on a correct understanding of constitutional morality. But this must be not only a one-way street. This is indeed an effort of assumption, and it is an effort, more importantly, of introversion. It is this introversion which will enable us to take, shall we say, not only in psychological terms of cognitive analysis, but even in terms of exploration into the deeper recesses of our mind, that are these candles shining brightly, and do we see light within our own selves as clearly and as necessarily as we can. Remember, if you see the light within, the light outside shall be seen. It is the light within which always is important. It is important that in the prayer song, which started with that beautiful line, was again in the context of what I have spoken about, fraternity. And can you believe that I'm a lawyer and I'm speaking from a constitutional standpoint, and that was a composition by one of the most sacred and extraordinary saints of this country without a manner of doubt. And he used the word fraternity. Why did he use the word fraternity? Because the word fraternity is also, as Thomas Aquinas said, something which will bind. Like conscience, it will bind. And anything which binds will provide you what Viktor Frankl said as man's search for meaning. Thank you.
Thank you very much, sir, for such an outstanding exposition of constitutional morality. And at the end of the lecture, I'm sure all of us would agree that at least we have made a good start to get ourselves into the thinking mode with the 10 commandments that you have given, that has framed the contours of, it has kind of laid down the contours of constitutional morality. And Mr. Gopal Subramaniam has been gracious enough to accept questions from the audience. And I shall moderate the question and answer session with an understanding that my question will be the last question. So I will give you as much time as you want and then ask my last question. So you can start asking the questions. I would encourage you to come forward so that it's also part of the recording. Please come here, ask your question. Yeah, please come. And those who want to ask the question, please form a queue. Come here. Yeah, you can face the camera and ask the
Very good afternoon, sir. My name is Chandrasekhar. I'm from the 5th year law school. So I have two questions for you, sir. My first question pertains to the judgment in the case of NAS Foundation, where two important terms were discussed. The first being public morality, the second being constitutional morality. And the court recorded that law could not be inferred from public morality. So my question is, the concept of res extra commercium came into existence because of the concept of public morality. And doesn't constitutional morality gain its strength from public morality? That's my first question, sir. And my second question to you, sir, is on the other term that was discussed in NAS Foundation, which was compelling state interest. And I relate this question in the case of Sabarimala, where there are conflicting views, where there is one sect of the society that wants to enter the temple and the other sect of the society that does not want to. And when the proportions are so severely disproportionate with each other, how will the state analyze such a situation in light of constitutional moralities? These are my two questions.
Thank you. Let me take up the first question. Sometimes public morality may be distinct from constitutional morality. What you mentioned about res extra commercium is a classic example where public morality may coincide with public interest or societal interest. So in other words, it could be an overstatement of what we call a societal interest. That would govern, shall we say, the cases of res extra commercium. Now, when Justice Chandrachud says that there is a distinction between public morality and constitutional morality, he is talking about popular sentiments about morality, popular feelings about morality. And he says that we cannot go by popular sentiments as a guide, or popular sentiments which may purport to be, shall we say, public morality, or which could have the cap of public morality. So that would be my answer to your first question. But the point is well taken, that res extra commercium is really more a facet of public interest, which is injurious to the life of people. And it is in that sense the state has a duty in its constitutional framework to prevent injury to people. It is in that sense we look at it. The second question you asked, and which is a fairly intricate question, which is that in a case like the Sabarimala judgment, what does the state actually do when it sees that there are divergent views in a judgment? Very good question. But let us look at it from the discipline of the law. The state is bound to obey the majority judgment because that is the law of the land. It is possible that there may be many people or sections of people who have points of view which concur with the ultimate conclusion of the minority view in that particular judgment. But it is equally possible for a large number of people to agree with what has been said by the majority. But I think there is one very important point which has been made by the majority, which I need to bring out to its credit. It is a matter for further reflection. Law evolves, so law is never static. But this is a very interesting point which has been made in the judgment, which is that sometimes private spaces may be actually the reflection of your public spaces, or public spaces may themselves be a reflection of any form of oppression which you may suffer in the private space. So in the sense of a temple being a form of a public space where a private belief of an individual could intersect with that space, the court said, if you come into that space, we will apply standards of freedom and constitutionality. They must be reasonable. If there could be a restriction, it must be a reasonable restriction. So they've said the genesis could be private. The genesis could be even in the practice of a religious belief. But when you come into a space, which is a public space, then you are not the person with the belief or without the belief. Then you become impersonal. In that space, the question is, what is that which actually prevails? And this is a very interesting subject matter, because this comes very close to dealing with areas of religious worship. It deals with very sensitive subjects. But having said that, it is not that the majority did not find a principle and place the judgment on a principle. It said that if there are women, if there are ladies, there are natural beings who have their own functions, and those functions are not meant to be determined as reprehensible. If there is any regulation, the regulation must be tailored to meet a particular need. And that is proportionality. It must meet a limited need. But if it doesn't meet a limited need, but that entire space is denied, lock, stock, and barrel, they felt it was a denial of freedom. Thank you. I want some more questions. Please come.
Good evening, sir. This is Tejaswini of third year, sir. I have a question to you. With regards to the 9 premises for the state, the government, and 1 from the citizens, sir, should defamation and sedition laws be decriminalized?
Should?
Defamation and sedition laws be decriminalized.
I would say without hesitation, 3 letters, madam, YES. Some questions from the side.
Good evening, sir. I am Akshaya Sagarika from the third year. My question deals with the final 10th point that you made about spaces. I'd really love to know what you feel about the right to be forgotten. That is in the GDPR principles, as well as the ordinance that has been passed recently, an option to get out of the Aadhaar system once you turn 18.
What a brilliant question. Fabulous question. Of course, you must have the right to be forgotten. Every citizen has a right to control the state. Every citizen must have the right to control the state. Why should the state follow your footprints all over space and the universe? And I'm afraid it is a danger. And why shouldn't you limit the danger? You must be in control of your destiny. That's very important. If you actually see the writings and literature on the footprints which we leave in the space, in the web, and in the internet arena, it will be quite shocking. Anybody can mine anybody's footprints and make a fortune. And you are right that if you have a single instrument of validation, like the card. It is like a wallet. It can serve any purpose at any place for the purpose of identification. You are leaving a trail behind. You have a right to be forgotten. And I think that is a very important part of the right to privacy. Why should anybody know where you're living? Why should anybody know your marriage status? Why should anybody know that there is a case against you? Why should anyone know your personal habits through your credit card statements? I think this is very important. And we don't realize that because of the inability to impose these clear sanctions, we suddenly hear that there has been eavesdropping. We suddenly hear that there has been a tape-recorded conversation. And we suddenly get to see something which is disturbing. The right to be forgotten, I think, is completely an integral part. And we are far ahead of European law. We are far ahead of any other jurisdiction. We must be so proud of ourselves. And I don't see why such an enlightened democracy, where in terms of demography and the percentages, we have the best part of our democratic electorate consisting of people who are in the prime of their youth, completely rational, very communicative, very capable, and I think they know what they're talking about. They're much familiar with what happens in the real web and in the dark web. Thank you. Oh, sure, please. Oh, sorry.
Good evening, sir. My name is Vishwas Bharadwaj. I'm a fourth-year law student here. My question is again on the concept of silence, which you highlighted as being meaningful in and of itself. While separation of powers contemplates that if the parliament oversteps its bounds, makes a decision, the judiciary can either uphold or reject it. My question is, if the parliament fails to act on a particular issue that it should be acting on, is it justifiable for the judiciary to act on it instead? And to that purpose, if I may just highlight an example, the question of Section 497 of the IPC, adultery law, because it was questioned thrice in the past. 2 of those challenges were made by women. The court upheld it as being a beneficial legislation for women, and in all 3 cases it was stated that this is a matter for the Parliament to consider. Parliament did not consider it, and after a span of about 30 years, the law was struck down. Therefore, do you think it's justified for the court to have acted when Parliament did not?
Again, there are 2 kinds of cases. There can be situations when Parliament does not act, but the matter is of such importance that it touches the fundamental rights of citizens, such as life, such as liberty, such as any form of exercise of free rights under Part 3. Then the court can intervene. It doesn't have to wait for a law to be made by Parliament. And that is not judicial overreach. So please don't ever be taken in by this dialogue of judicial overreach and judiciary overstepping its limits. This is an argument which I have heard too many times. But don't be ever carried away by that. So whenever there is a cause and there is a case, the court is expected to intervene because it is its duty. It is supposed to be also protecting the rights of citizens as much as the executive is supposed to do. We also must understand that under our constitution, the courts have been given the power to issue writs and compel obedience. And that is very important. That tells us that the constitution intended that our courts would be efficacious. The second point which you asked about a penal code provision. Now, in a penal code provision, you can either uphold it, you can either declare it as null and void. But In a penal code, the court cannot substitute a brand new provision. That is completely outside its province. That is legislating. So if suppose the court said that we are now inserting a new section 497 or something to that effect, or an amended section, that would be unacceptable. But in an area which does not amount to legislation, but amounts to judicial behavior, in an area where the executive is completely without any form of, shall I say, it is not even alert to a situation relating to human rights. Suppose, let's say, there's a disaster. Human beings have fallen by the cliff. There is a road which has fallen off the cliff, and people have to be rescued. Teams have to go. There are multiple actions to be taken in disaster management. A court can intervene. It does intervene. So we must understand that public interest litigation petitions are not entirely meaningless. Public interest litigation petitions many times may be motivated, but merely because some of them could be said to be motivated, it doesn't give sufficient ground or reason to believe that the whole lot must be dismantled and judiciary must be denuded of its power to act in a broad-based manner. Thank you.
Good evening, sir. I'm Mansa Srinivasan from final year. You had stated that constitutional morality is equally important as constitutional legality. So do you think judicial review of a law should be allowed solely on the ground of illegitimate legislative motive?
Illegitimate?
Legislative motive or considerations.
Illegitimate, legislative motive.
Yes.
Okay, very good question. Excellent
Yes, sir.
question. If there is a law which has been enacted but is actuated by an improper purpose, it's sometimes a little difficult to say that a legislative act is actuated by an improper purpose. But if the arbitrariness of that purpose is so evident from the law, it can be struck down. It directly touches upon the legitimacy. And such a law can be struck down as an unreasonable provision, as an arbitrary provision. That's why you have 14, 19, and 21.
Thank you, sir.
Yes, someone here. I must have a couple of questions from this right-hand side. Oh, yeah, sure. Yes, come. Somebody is coming.
Good evening, sir. I'm Vigneshwar from final year. The premise of the definition of constitutional morality, as you mentioned in the beginning itself, is that it is objective as opposed to being subjective. Later on, towards the end, when we were talking about religion and the constitution, though for theists it provides for faith, for atheists it provides for conscience, both these concepts are subjective. So with regards to constitutional morality, when we talk about religion, is it subjective as opposed to a blanket objective that you had premised? With regards to religion, is it subjective alone, or is it a blanket objective definition that we have to give to constitutional morality?
Thank you. When I said about constitutional morality, I mean totally objective constitutional morality. It should not be mixed up with the right to practice religion or the right to practice one's conscience, depending on whether you're theistic or agnostic or atheistic. Now, what you feel as a citizen by the exercise of your religious beliefs or by virtue of the power of your conscience, being an agnostic or an atheist, or even by the power of conscience in accordance with religious beliefs, is subjective. That doesn't come within what we call as constitutional morality. However, if there is a danger to your practice of this particular freedom, there, the duty to protect the practice of that freedom is a part of constitutional morality. Am I being clear?
Yes. So in that case, will public morality prevail over constitutional morality?
Public morality?
Yes.
No. So constitutional morality is actually at the highest. You see, it is like this. It is like a building block. We must also know that the highest standard, and shall we say the most fundamental standard, is the Constitution. Constitution then becomes the guiding document, and that throws light on what exactly is being examined. If suppose what is being examined is not an issue within the Constitution, but is an issue within the individual, then we don't apply constitutional morality. Thank you. Some more? Yes. Now the gentleman there. Yes, you wanted to ask.
My question is very similar to this.
Oh, you can go ahead, ask another.
So my question is very similar to the question that was just asked. You mentioned first that the standard for constitutional morality is objective.
Yes.
But as per the doctrine of constitutional trust itself, the Constitution is effectuated by its functionaries. And in many places, through the scheme of the Constitution itself, these functionaries are placed at odds with each other, say through checks and balances. And therefore, you will not have one group of people deciding what constitutional morality is. In effect, it should be decided as a matter of conflict between two subjective groups, say, for example, the Parliament and the judiciary over a particular subject matter. In which case, how is it possible to have an objective standard when it is two separate constitutional functionaries who are competing to decide what the standard is?
Very good question again. First thing is that in our constitution, judiciary is supreme. So even if there is a conflict between the executive and the judiciary, judiciary has the last say. So on all matters relating to adjudication of the Constitution, under our Constitution, judiciary has the last word. Because it has the last word, it's not infallible, but it has the last word. It's final and binding. Having said that, we applied this theory of constitutional morality when it comes to conduct with reference to a claim made under the Constitution. So when a person purports to act under the Constitution or under the color of the Constitution, then the question arises, has he acted in accordance with its spirit? Has he addressed to himself relevant constitutional considerations? So what used to be traditionally applied in administrative law as principles of judicial review, that has an authority address relevant factors, has it taken into account irrelevant factors, has it given a hearing, did it have adequate material, did it apply its mind? All those principles are principles germane for judicial review. But in constitutional morality, the court applies objective standard to determine what would be the true intention of the framers of a living constitution. Because it's a living constitution. So a living constitution means the constitution does furnish an answer to the conflict which is before the court. That is why it is called constitutional morality. So constitutional morality is to suggest that a living constitution is capable of providing answers as and when needed for resolving a dilemma or a conflict.
And since the judiciary has the final word on interpretation of the Constitution, it has the final word on this as well.
Oh, yes.
Understood.
It has definitely the final word. You will find, as I said in the course of my talk, you would have noticed And I'm very proud to say, as an Indian, that how honored one feels seeing Dr. Ambedkar's beautiful portrait in Gray's Inn. And it's a matter of such great pride, because his work in understanding Constitution and how it should actually reflect contemporary ethos of Western philosophers like Goethe is very interesting. And nobody thought about this so closely, that we must imbue it with constitutional morality. Now, mind you, so this is not a kind of a phrase which has been coined out of a Scrabble board. It is actually out of a certain degree of reflection. So there is a lot of, shall I say, if suppose I were not a lawyer, I looked at this as a purely sociological exercise, I would say here I see the intersection of modern political theory plus cognitive psychology plus, shall I say, a written guaranteed text in the Constitution plus tools of interpretation plus, shall we say, choices of reasoning and which is better and which is not better. And what actually tilts the scales is constitutional morality. So that which subserves constitutional morality, which takes forward the three preambular values. So it's done very brilliantly in this judgment of Justice Chandrachud. You see, you either have democracy, equality, fraternity, otherwise you also fall back on justice. So you see, it's perfect. You have a quartet in a way. So you can always refer to a fundamental principle for finding out the spirit of the Constitution. When we use the word democracy as well as, shall we say, justice, both these words, they automatically mean accountability. So accountability does not have to be through a Right to Information Act. Accountability by itself is inbuilt in the use of the expression democracy. There is another expression which is republic. What is the meaning of the word republic? The meaning of the word republic is what that wonderful gentleman said about freedom of faith and conscience. In a republic, each one has his faith. It's a private matter. But as a citizen, he is entitled to his pool of rights, which are available under the Constitution. He defines himself as a member of the republic by being a member of the republic. It is like Plato's republic. And we are a part of a society where we have, shall we say, a transcendental identity which has been given to us by the Constitution. So, while we have the right to practice religion, but religion does not limit our identity.
Thank you.
Good evening, sir. I'm Revant, final year law student. So I have a doubt regarding the living character of the Constitution. As you told us that our Constitution is a living Constitution, my idea is that any law should emanate from the people. And the Parliament is in the best position to judge what the society needs. I feel that the judiciary right now has become hyperactivist because constitutional morality is a concept which is subject to various interpretations, and judges who have different ideologies, they might interpret constitutional morality in their own way. Therefore, don't you think that Parliament is the right the body to determine what the law is, what the needs of the society is, rather than the judiciary, and the duty of the judiciary primarily being to declare the law and not to make the law?
The first is that we are not talking about constitutional morality to be confused with subjective ideas of judges which are independent, individual preferences of judges. they don't come within this concept of constitutional morality. Constitutional morality is a very objective standard. And the objective standard is the Constitution itself. But we are using the word constitutional morality because we are actually using the Constitution to interpret, shall we say, certain fundamental aspects which are brought before the court. When it applies the principle of constitutional morality, and it is often in the cases of breach of a constitution, very often the question of constitutional morality comes when it's a question of acting, claiming to act within the color of the Constitution or in breach of the Constitution. But what is important is the standards are highly objective. There, it is very unlikely that three different judges will take three different views. So the point which the other gentleman made about the Subramaniam case, there it was not on the question of morality that the judges actually differed. They differed on the basis of, shall we say, should a certain degree of autonomy in the matter of maintenance of a temple and its tradition and so on and so forth be left intact as a part of the fundamental right to practice religion, which is quite different from, shall we say, the question of constitutional morality. So this is, of course, an evolving concept. On the question whether Parliament is best suited, Parliament will not be suited to be a judge of its own cause, because Parliament can only make laws as best as it thinks it should. But it is correct that we attribute wisdom to the legislature. It would not always be right to undermine the legislature, not at all. In fact, legislatures can actually be great bulwarks of social change if they decided that the constitutional goals in Part 4 had to be achieved. We must not forget that education, prior to it becoming a fundamental right, was in the directive principles. And then now it is a fundamental right under Article 21A of the Constitution. So legislatures have a very major role to play. We have to treat them with respect. But the performance of a legislative function is a very serious function in this country. It is not about power. And that is the point I made in those 10 premises. That when I said that even we have to have a perspective, everybody must have a perspective about constitutional morality, because it comes with responsibility. So we are lucky to be free citizens, therefore it comes with responsibility. Anybody who has power under the Constitution, whether he's in the executive, legislature, in the judiciary, it comes with tremendous responsibility of being accountable to the Constitution.
Thank you, sir.
That's the last one. All right. No, there one lady there? Oh, okay. All right. Please.
Do you have the copy?
So we just talked about everyone having different perspectives. So I just wanted to ask, since the constitutional morality allows us the right to be different, and we have the right to be different, but everyone has naturally, as we walk and we are going about with our lives, we naturally develop prejudices. So how do we differentiate between what is acceptable in society to be different and what is unacceptable deviance?
Can you just step up, please? You said acceptable to befriend?
Yeah.
Yes, to be different.
What is, we're allowed the right to be different, but how do we distinguish between what is acceptable difference and what is unacceptable deviance?
Oh, right. Thank you. Brilliant question. Brilliant. Very good question. First, I think this is to be answered very carefully, and I want to go in my answers very slowly. The first is, everyone is different. That's the first sentence. And it's an unqualified sentence. No two are the same. No two twins are the same. This is based on empirical research. So if everyone is different, you said, what is the level of acceptability insofar as the rights of others are concerned vis-a-vis their difference? Brilliantly put. And you rightly said we could have prejudices. Let's give some examples without trying to be pinpointing anybody, but just giving you an example. Very often we are used to seeing certain kinds of people in our daily lives. Suddenly one day, you see a whole lot of different people. It first surprises you, and suddenly you feel awed. But the odd, slowly, swivels into a bit of a prejudice. And then the prejudice feeds on itself. It's also like a self-perpetuating, green-eyed monster, which is called prejudice. And before you know, you're beginning to act in terms of prejudice. The moment your act offends the dignity or the equality principle or diminishes the other person in the fact that the other person is different, it is a violation of the law. It's a violation of the equality principle. The entire basis of the act against atrocities against people who belong to the members of the scheduled castes and scheduled tribes is a very important pointer to you. Our society has not been rid of all evils, which is why even today you have prosecutions under this law. I mean, the Constitution was enacted when? And we talk about a casteless, we talk about egalitarian society. But do we actually practice it? If suppose people of disadvantaged background suddenly cropped up in front of us, what would be the reaction? Would we be able to handle it? But the moment you act out of that prejudice, you offend the principle of equality. Which is why I think Justice Chandrachud, again, this is all law in the making, and these are judges. I mean, the judges of the court, Justices Nariman, Justice Chandrachud, I mean, all of them in the Puttaswamy, all these cases, they've contributed a lot to this kind of jurisprudence and thinking. Because what is the thought? They say your mental attitudes themselves of equality must be nurtured by constitutional morality. I'll give you one example. It's very interesting, and maybe you should check it out. This is about a South African Supreme Court judge. And, he has an HIV problem. And he is not ashamed of it. He was able to speak up, and he was able to fight for those who were not privileged enough to get medicines. But what is more important is that you could see from his writing and his lectures that one of the principles of equality is, do you engage with another human being in a relationship which is going to degrade that other person in his life? If you ask him to do tasks which are inconsistent with human dignity as a part of employment with you, will it not actually affect the equality principle? And he takes the view it does. which is why he has said adversely against various people who used money for the purpose of engaging various other people to do work for them. This is a very interesting point which you've raised, which is why the fight is also with ourselves. So this is not only, shall we say, a peroration for the executive, it is also ultimately a peroration unto ourselves. Oh, yes.
Yeah. Sir, my last question is from the first statement that you made, about which already 2 questions have been raised, that constitutional morality is an objective standard. Now, will you rephrase your definition? If I am to believe that the objective standard that's applicable for institutions and constitutional authorities are different when it comes to individuals. Because very rarely, when these standards are framed for institutions or constitutional authorities, there isn't a chance for conflicting views. But when it comes to individuals, and especially in the light of the statement that you made that the individual right determines collective well-being, and given that there is enough conflicting views, how can objective standards be established? And if you feel that it can be, again, who can best reflect individuals' views with an objective standard, whether it's the sovereign power or the judiciary?
Thank you. I need to make this clear that you can have 2 kinds of situations. You can have the organs of the state fighting with each other, or we see an organ of the state which is actually violating the Constitution or interpreting the Constitution, and then we bring into focus principles of constitutional morality. That's of institutional actors. You're correct that institutions also have individuals. But we must view those individuals as representative of the institutions. So those are not the individuals we are talking about for the purpose of conflict. However, if we are talking about individuals who are citizens per se, there can be a conflict of opinions between 2 individuals. But how are conflicts between 2 individuals resolved is a question. Conflicts between 2 individuals are resolved if it is a question of, shall I say, rights, assertion of rights. The rights of one is not meant to abrogate the rights of the other. The rights of one or the opinion of one may be different from the opinion of another. That doesn't worry. So 2 people in this room can have absolutely polemically opposite views. It doesn't involve constitutional morality on an issue. But if suppose, let us say, that 2 different views lead to one person rushing at the other end to actually prevent the other person from expressing a view, it infringes the freedom of that other person, then a question of the constitutional morality of the respect for free speech, which should be accorded by the individual, by the institution which is housing both of them, will definitely come into play. So the objective standard always occurs on a situation. It is occasioned by a situation. And there can be no catalogue of these situations where constitutional morality would be called as a kind of an aid to help matters of interpretation. But constitutional morality is only to give us what we call as the impulse of a court. If you want to know what is my blood pressure, you have a blood pressure meter to read it. But if you want to know how is the court going to look at it through the lens of the Constitution, then constitutional morality is a very helpful guide to come to the conclusion whether the court will uphold this action and how does it view this particular conflicts. Therefore, we must bear in mind that the Constitution itself does not contemplate conflict. Constitution contemplates differences by all means. The Constitution promotes, shall we say, diversity. There's nothing wrong with diversity. There's absolutely nothing wrong with multiple ways of thinking and feeling and behaving and imagining. And after all, just look at the poetry, for instance, the Tamil poetry which has been published in the last 10 years. This poetry which has been published by some very young, extraordinary poets who have written out of direct personal experience. Now, some have written out of imagination, some have written out of personal experience, but it tells you that that power of expression is a part of free speech. And if we don't give these rights their full play, which is what Justice Chandrachud says, everybody's freedom is like that universe. That universe must not collide with some other universe to put the other man's rights in jeopardy. It's not that he's the sole, shall we say, one citizen in this whole nation. There are many, which is why when we travel in a bus, we always make way for the others in the bus. We make way for ladies to sit comfortably, elderly women to be assisted. This comes naturally to us. But why does it come naturally to us? It comes naturally because it is a part of the binding nature of cohesion. So this whole purpose of constitutional morality is to bring in an element of cohesion, an element of support, an element of sustenance in the matter of answering an issue. And that is why this phrase is not a phrase of very limited import. It is a phrase which is very philosophical, it is intellectual, it is very demanding, but I would still say very highly objective. It is not that I like oranges, therefore my constitutional morality reads this way. Another person says, I like pineapples, it reads this way. No. It is expected that the constitutional morality on the rights in question, the provisions of the Constitution in question, must veer around to the same concentric circle.